On May 9, 2022, rapper Jeffrey Williams, widely known as Young Thug, was indicted in Fulton County, Georgia, under the state's Racketeer-Influenced and Corrupt Organizations (RICO) law. Prosecutors alleged that he led a criminal street gang and charged him with racketeering conspiracy, participation in criminal street gang activity, and multiple firearm and drug-related offenses. As the highly publicized trial approached in June 2024, an important dispute arose involving a state witness. The witness refused to testify despite receiving immunity and continued to invoke his Fifth Amendment right against self-incrimination. As a result, the court held the witness in contempt while attempting to secure his testimony. Chapter 2. The ex parte meeting. On June 10, 2024, Chief Judge Ural Glanville held a private ex parte meeting inside his chambers with the witness's attorney, and prosecutor Adrian Love. The defense team was not invited and had no knowledge that the meeting was taking place. Following the discussion, the witness agreed to testify. The defense later argued that this private communication violated Rule 2.9 of the Georgia Code of Judicial Conduct, which generally prohibits judges from engaging in one-sided communications concerning an active case without all parties being present. When defense attorney Brian Steele learned about the meeting, he immediately questioned the judge in open court. Rather than addressing concerns about the private conference, Judge Glanville demanded that Mr. Steele reveal who had informed him about the meeting. That Mr. Steele declined to identify his source, explaining that doing so could violate Rule 1.6 of the Georgia Rules of Professional Conduct, which requires attorneys to protect confidential information related to their clients and legal representation. Judge,
is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, and with criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Okay. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And
well, no,
notice of that
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second.
I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H, and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
They still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom. So we would ask that they be allowed to.
I don't want them in my jury box. Okay. No.
I understand. May one additional attorney come in, then Alex Susser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, certainly may, sure.
Great. Alex Susser.
Hasty's conduct didn't rise to a level that necessitates warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So, and I distinguish your two cases that you've given me thus far.
Oh, those were only the initial two. I had a couple others.
Okay, go ahead.
Glanville responded by finding Mr. Steele in direct criminal contempt under Georgia law, concluding that his refusal to obey the court's order obstructed the administration of justice and justified immediate punishment without a separate hearing. Chapter 3. Due process debate following the contempt ruling. Defense attorney Ashley Merchant immediately objected. She asked the court to clarify whether Mr. Steele was being held in criminal contempt, and Judge Glanville confirmed that he was. Ms. Merchant argued that because criminal contempt carries punitive consequences, Mr. Steele was constitutionally entitled to full due process protections before any punishment could be imposed. She maintained that he should receive formal notice of the charges, a proper hearing, and an opportunity to present witnesses and evidence in his defense. The disagreement marked the beginning of a major legal battle over judicial authority, attorney ethics, and the constitutional safeguards required in criminal contempt proceedings. Merchant argued that because Mr. Steele was facing criminal contempt, he was constitutionally entitled to due process, including proper notice of the charge.
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you, because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, and as to how that information was disclosed. That's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm going to disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody. It goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there, because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that, because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay. Well.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also
But you got the information. But here's the thing. You got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay. I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Charges and a fair opportunity to defend himself. She pointed to the 1979 Georgia Court of Appeals decision in re McClarty, which recognizes that attorneys acting in good faith are entitled to procedural protections, including a formal show cause order and advance notice of the witnesses who will testify against them. To preserve those rights, Ms. Merchant formally raised the issue in open court, insisting that Mr. Steele should receive a written show cause order and a complete witness list before any contempt proceedings could move forward. She also relied on the 1994 decision in re Hasty, arguing that criminal contempt cases generally require a separate hearing before a different judge unless the alleged misconduct creates an immediate disruption that threatens the court's ability to function. Judge Glanville disagreed with that interpretation. He distinguished the Hasty ruling by stating that it applied only to situations involving sudden and disruptive courtroom behavior. According to the judge, Mr. Steele's refusal to reveal his source was an
Judge, there's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will say for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record. In this case, he has filed a motion to set aside the contempt. He's filed a motion for a supersedis bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself with the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant a bond. At this point, grant him a bond on that issue.
You don't get a supersedis bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
just the case law on that is in Ray Hughes.
Hold on. The supersedis bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that in fact I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond.
I'm not going to grant him a supersedious bond.
And so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and a $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Going act of non-compliance rather than an emergency interruption of court proceedings, making the hasty requirements inapplicable. MS. Merchant challenged that conclusion, arguing that a court cannot impose summary criminal contempt on an attorney without clearly demonstrating that the attorney's conduct actually interrupted or obstructed the proceedings as they were taking place. Judge Glanville responded by relying on the 1974 case Moody v. State, which recognizes that judges have broad authority to preserve courtroom order and, in certain circumstances, may act without the usual due process procedures such as formal notice or a separate evidentiary hearing. The judge maintained that the central issue was not simply Mr. Steele's refusal to answer, but the disclosure of a confidential ex parte meeting that had taken place in chambers. He argued that preserving the confidentiality of those judicial communications was essential to maintaining the integrity and authority of the court. However, the defense maintained that compelling Mr. Steele to reveal his source would force him to violate his professional and ethical obligations as an attorney. The defense argued that forcing Mr. Steele to identify the person who informed him about the private meeting would directly conflict with the attorney-client privilege and the ethics.
When he tells me what the basis of the conversation was, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
Judge, and that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and a $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person, okay, I'm sorry.
Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out, I'm gonna think about it.
Thank you.
Okay, all right. So we'll be in recess about 5 minutes.
Duties imposed on lawyers. Recognizing the difficult position Mr. Steele had been placed in, Ashley Merchant argued that he also had Fifth Amendment protections against compelled self-incrimination, particularly in light of earlier suggestions that the information may have been obtained through improper means. She requested that the court conduct a formal hearing, emphasizing that an attorney should not be held in summary criminal contempt simply for filing or pursuing a motion in good faith. Another member of the defense team, Alex Spiro, then asked Judge Glanville to clarify exactly what type of contempt proceeding Mr. Steele was facing. In response, the judge confirmed that the court was proceeding under a direct criminal contempt finding rather than civil contempt. The distinction between the two forms of contempt became a major point of discussion. Civil contempt is primarily designed to compel compliance with a court order. Its purpose is remedial rather than punitive, meaning that any fine or jail sentence typically ends once the individual complies with the court's directive. Criminal contempt, however, serves an entirely different purpose. It is intended to punish conduct that has already occurred and to uphold the authority of the court. Because it addresses a completed act instead of encouraging future compliance, the punishment is fixed and cannot be avoided simply by later obeying the court's order. Because criminal contempt results in a fixed punishment, the sentence cannot be reduced or eliminated simply by complying with the court.
Well, now stand next to your attorneys.
Court's order afterward. For that reason, the defense argued that Mr. Steele qualified for a supersedeas bond after Judge Glanville characterized the matter as a criminal contempt conviction. Such a bond temporarily suspends the enforcement of a jail sentence while an appellate court reviews the case. The defense maintained that Georgia law gave the judge discretion to grant the bond in order to preserve Mr. Steele's liberty until the appeal could be decided. Attorney Alex Spiro further argued that Mr. Steele had been placed in an impossible professional position. Under Rule 1(6) of the Georgia Rules of Professional Conduct, lawyers are prohibited from revealing confidential information related to the representation of a client without informed consent. Complying with the judge's demand could therefore expose Mr. Steele to serious ethical consequences. The defense also warned that violating this duty could trigger disciplinary action under the Georgia Bar's emergency suspension rules. If the disclosure were viewed as a serious threat to the administration of justice, the state bar could initiate an immediate investigation that might ultimately lead to a temporary suspension or even the loss of Mr. Steele's law license, subject to review by the Supreme Court of Georgia. Relying on in re Hughes, Mr. Spiro argued that the contempt allegation should be treated as a criminal misdemeanor rather than a summary contempt matter because its purpose was to punish past conduct instead of compelling future compliance. The defense also cited Georgia law limiting a superior court's contempt authority to a maximum penalty of 20 days in jail and a $1,000 fine. Because the proceeding involved criminal punishment, they argued that constitutional due process protections had to apply, including a full evidentiary hearing before an independent and impartial judge rather than immediate summary punishment. Despite those objections, Judge Glanville declined to change his ruling. He found Mr. Steele in criminal contempt and ordered him taken into custody to serve a 20-day jail sentence. Immediately afterward, the defense began seeking emergency appellate relief. Immediately after the contempt sentence was imposed, Mr. Steele appealed the ruling and obtained an emergency stay from the Supreme Court of Georgia, temporarily preventing the jail sentence from being carried out while the case was under review. Several months later, in October 2024, the Georgia Supreme Court unanimously overturned the contempt order. The court concluded that Judge Glanville should have recused himself because. Thanks for watching, and don't forget to subscribe for more in-depth legal case breakdowns.